Hi, I'd like to offer a few thoughts from a different perspective that I would like all of the participants to think about as well. What does all of this do in global convergence of competition law enforcement in the merger control field? So we're observing trends of isolation from a political perspective everywhere, and these also have their reflections in the antitrust enforcement and also merger control review processes too. But one thing that that we don't think about very frequently, and doing competition law in Turkey, so being a Turkish competition lawyer as well, I think I can put on that hat, is sometimes some sophisticated new steps that are taken in enforcement leader nations, in enforcement leader jurisdictions, may have the unwanted effect of giving way more way to arbitrary enforcement, to a misunderstanding of what flexibility is in those peripheral jurisdictions, and a lot of room for speculation and scaremongering, basically in the name of, oh, we're not looking at merger control analysis as a snapshot anymore, we're looking at it as a process. So one has to always keep in mind, I'm not saying the European Union or the Commission or even the member states have to keep in mind Turkey, Brazil, India, or what have you, while coming up with their rules and principles. But what I am saying is that we should all intellectually note very well that some newer steps that are taken in these jurisdictions are having unwanted effects in some other jurisdictions that are equally important for global transactions to go through. And this is not only in the competition law field, it is most notable in the competition law field, but you could take very many other fields as well. You would come up with the right to be forgotten in the EU, and in a country like Turkey, the right to be forgotten might be misunderstood as the right of a politician to be free from all corruption charges that happened in the past. So newer generation rights, if you will. Here, what is a little threatening, I would say, is the idea that more and more jurisdictions are subscribing to, and this is where I'm coming to what Pascal said, more and more jurisdictions are subscribing to the idea that competition law may have prime objectives other than maximization of welfare. This is extremely dangerous for the global convergence side of things. The minute you open that door, a lot of countries are going to jump on it. Some of them did already, like take South Africa. They're already openly pursuing employment goals in merger control. And there are some jurisdictions like Turkey that are quite fanatically still only following consumer welfare maximization theories or social welfare maximization theories. But if you were to open this door, then under the name of keeping the inflation under control, under the name of national economy interests, employment goals, even shameless political agenda, you might be actually looking at a ripple effect of what is more technically happening perhaps in some other leading jurisdictions, because there are built-in mechanisms of keeping those goals under control in those jurisdictions. And a global merger control enforcement may really be hit with this kind of an approach. I'm not saying that new theories shouldn't be advanced. You know, innovation theories of harm are also newish, and jurisdictions like Turkey will have to come to terms with looking into dynamic efficiencies in a meaningful manner. There's no issue, or this snapshot versus process. Of course, without engaging in speculative scaremongering, you will have to do these analyses. But when it comes to accepting other policy objectives other than purely economically analyzable ones, let's say, it is really dangerous. I had even taken this point, and this is my last sentence on this matter. I had even taken this point when the U.S. horizontal merger guidelines was changed in 2014. I had published an article, and I had indicated that the absence of the bright line rules now, after the new back then U.S. horizontal merger guidelines, is going to hit some of the emerging markets analyses, and this is exactly what happened. So what happened was emerging market competition authorities followed that lead, and they said, yeah, we need to do a case-by-case analysis. These bright line rules in the economic sphere don't work. Whereas they didn't have the same kind of economic analysis tools that the FTC had. And therefore, very quickly, it has turned into a very speculative ball game in the hands of emerging market competition authorities. So I always invite people to also think if global merger control is the ultimate ball game, because most transactions are happening beyond borders, then these kinds of effects can be difficult to absorb over time. Thank you. Sure thing. Thank you for this. So I find this extremely important, the discussion that we've undertaken today. And obviously, the trends in the EU are having an impact on other jurisdictions as well. One thing that I would like to discuss in these 2 minutes is obtaining information from the Commission and from some member states' authorities by the non-member state agencies, and the importance of that. Sometimes it so happens that the non-member states agencies are waiting for the decision of the European Union Commission or the Bundeskartellamt for no apparent reason, really. It's just because they don't understand why there is the delay that is happening there. And there are some distinguishing factors of the competitive dynamics of what is notified in the EU or in the UK to the CMA, or in Germany to the German cartel office, the Bundeskartellamt. Yet the CAGI wouldn't know about this, or the Turkish Competition Authority wouldn't know about this distinguishing factor, something that is specifically belonging to that jurisdiction as a concern, and there would be an undue weight. I'm seeing this kind of a weight more and more, also because the competition authorities of other jurisdictions are really not liking to find out that Dow DuPont was going to be the big deal merger control matter of the year, and they have cleared it in 21 days, right? So they want to keep an equal footing in these kinds of things, but sometimes it's due to not knowing enough. So the point I would like to make is that more collaboration with competition authorities, exchanging notes and information on the substance may be encouraged, and some degree of effort may be spent also from the EU perspective. Maybe the flexibility in choosing cases might be, so going back to the original discussion we had, flexibility in choosing cases to be reviewed might help in that direction, because there would be presumably more administrative capacity to invest more time and energy in coming up with a more holistic view on these things. Because part of the reason why some agencies around the world are in the dark is because the Commission has its hands full, basically, and they can't interact with the authorities of other jurisdictions as freely as they would like. I'm setting aside the waiver problems and other issues. I'm assuming that the parties want this to happen.